my lords, my lady, I was on added matter. I was looking at the judge's 3 reasons, and I'm going to start with her last reason, and that is the wider teaching of the specification. And I'm very aware that my lords and my lady have probably read the A specification and understand the points I'm going to make, but it is important to go through it, because otherwise what you end up doing is looking at the building security embodiment without that surrounding material, which is really important. And so I'm going to be starting in supplementary bundle tab 2, which is where the A specification is, at page 57. And my lords and my lady will already have appreciated that there are various figures, and the first one I want to talk very briefly about is figure 1, which is mentioned towards the bottom of page 57, and it's a schematic illustration of a system in which embodiments of the invention can be implemented. And if we go over to page 60, it describes various elements of the system, and at the top of page 60, it talks about the computing apparatus 10 comprises a controller 100, and then if you go down to lines 9 to 10, the controller 100 is operable under the control of the computer readable code to control the other components, such as the display 104. So clearly telling you that here obviously you've got a computer with a standard computer display, as my learned friend accepts. Figure 2 comes next, that's lines 13 to 14 on the same page, page 60. It's a schematic illustration of a method according to a first embodiment of the invention. And it sets out various steps of the method on that page. And first of all, at line 22, it says that in step S2-2, the computing apparatus receives and displays the web page. And then further down towards the bottom of that page at line 29, it explains that the web page comprises an encoded information item 112, which contains encoded information. In this example, the encoded information item 112 is a graphical object GO, which is depicted in the figures as a QR code. And if we go over the page, it then explains at the top of the next page, the GO address information item comprises an address of the computer apparatus 10 on or by which the GO112 is displayed. So all of these things making clear that you have got a computer with a display. And then if you go on to page 67,
page, sorry, I missed the book.
67,
67.
Please. You'll see that what we've got here is figure 3, and that depicts an alternate system in which the invention can be implemented and illustrates the method according to the invention. And then towards the bottom of that page, it describes various steps. And in step S3-2, the computing apparatus receives and displays the web page. And the login page, it says at line 25, is described with reference to figure 2 and comprises the encoded information item 312. Again, that's a QR code in this example. And it says that the GO address information item comprises an address of the computer apparatus on by or which the GO312 is displayed. And if my lords and my lady want to do so, then you can also turn back to pages 49 and 50, where you've got the illustration, which shows very clearly that the QR code is being displayed on the display of computing apparatus there, a laptop computer. And so that is what you've got in the descriptions of figures 1 to 3. So all about computers, basically. You've then got at page 72 the building security embodiment, and I'm going to come back to that in a minute. But before I do, I just want to mention what my learned friend referred to as the disjunct, which is just before the building security embodiment. And he particularly places weight on lines 7 to 8, which say it will be understood that the invention may be implemented within systems other than those described above. And he says that signposts to the reader that what is coming is something different. Now, I accept that it is something different because we're now going to come on and talk about a building security embodiment, in particular this electronic door lock. But in my submission, it's not telling the reader that this is going to be done in a completely different way, i.e. not using a computer. And indeed, if one moves a bit further down the same paragraph, it goes on to say, although these are described briefly, it will be understood that the operations may be substantially the same as those described above and may include some or all of the same steps and features. So that is not really consistent with this big disjunct or break that my learned friend relies upon. So I'm just going to move forward, because I'm coming back to the building security embodiment, to the next page, page 73, which is an alternative embodiment, which is a checkout device. And what you'll see in that embodiment is that it uses the reference numerals that we've seen already from figures 2 and 3, 112 and 312 being the encoded information item which is displayed. And it's clear that that is being displayed on a computing apparatus 10, which is a checkout device, which is what it says at line 11. So it's completely clear that that is talking about computing apparatus and display on a computing apparatus. And then moving forward to page 74, there's another embodiment, the ATM system, which again, the computing apparatus is an ATM. It says that at line 6 to 7. And then it talks about the ATM produces and displays an encoded information item 112, 312. Again, these reference numerals are all references back to figures 2 and 3. And again, it's clear that this is a code being displayed on the display of a computing apparatus, namely the checkout device. Sorry, the ATM. Then we've got, on the next page, page 75, the self-service shopping environment, which is the smart tag embodiment. Now, my learned friend had placed quite a lot of weight on this in his written skeleton argument. He didn't adopt that in his oral submissions. And in my submission, that was for good reason, because essentially we know, or the skilled person knows, because there's a reference to it in line 3, that this is a smart tag. So in my submission, it's clear that that's going to be some kind of device or computing apparatus. It's not, you wouldn't call it a smart tag in my submission if it was just a static sign. I mean, the other problem with my learned friend's submissions in relation to this is that they didn't at trial say, oh, well, you can find it clearly in the smart tag embodiment. Alternatively, the smart tag embodiment helps you find it in the building security embodiment. And when you're trying to show that you can find something clearly and unambiguously without hindsight in a patent application, not having made the point at trial seems to me slightly problematic, because it can't have been that clear or unambiguous. But in any event, I say, for the reasons that are in my written skeleton argument, that this simply doesn't help them, because there's nothing in this smart tag embodiment which helps my learned friend show that this is a static, unchanging sign of the type that he needs to find in this application. And so we then come to the final two parts that I want to rely on as part of the wider context of the specification. First of all, page 77, which is the teaching at lines 8 onwards, that the invention is particularly effective in this respect in embodiments in which the computer program code for generating the encoded information is stored on the computer apparatus and is configured such that the encoded information item is only provided, i.e. displayed, etc., when a direct communication with an application running on the web server is established. And so that, in my submission, is an embodiment, that the preferred or best embodiment, which is only going to work if you have a computer display. And there was a bit of discussion of this before the short adjournment, and I think it might just be worth showing, my lords, in this context, paragraph 150 of the judgment. So that's back in the core bundle at page 33. And the reason for going to that is because there the judge records that in cross-examination, Professor Martin accepted that the skilled person would understand this teaching to require the display of the GO on a computer screen. It follows if the claimant's construction is correct, it means that this advantage of the invention is lost. So this advantage can't be achieved with a static sign. Now, obviously, it's possible that it's something that's then not, that the patentee hasn't gone on to claim. But it's all part and parcel of what we're seeing in this patent, which is that it's all about computing displays on a computer, and that's what gives you this particular advantage. And finally, of course, we have the claims themselves, and obviously for the which are at page 80, for the purposes of added matter, I accept that the patentee doesn't have to show that it can find the static, unchanging, non-electronic sign in the claims. It does have to show that for the purpose of extension of protection. But I still pray and aid the fact that when the skilled person is reading this patent as a whole, they are going to see from the claims that it has to be a graphical encoded information item, which is displayed on a display of a computing apparatus, which on its normal and natural reading is clearly talking about an electronic display on a computing apparatus. So that was one of the judge's main reasons, the context of this specification as a whole, for saying that when you come to read the building security embodiment, you can't find, without hindsight, this static non-electronic sign that the patentee needs to find. And I'm going to come now to the building security embodiment, which is back on page 72. And the appellant has to find the clear and unambiguous disclosure from the two sentences. So the first sentence is starts at line 15, the encoded information item 112312, such as a GO as described above, may be displayed on a sign geographically proximate to the electronic door lock. Alternatively, the GO 112312 may be provided on an electronic display geographically proximate to the electronic door lock. And essentially, the appellant's case turns on, or the way in which it says it can find the non-electronic static sign, is by doing a sort of compare and contrast between the first of those two sentences and the second sentence, because of the word alternatively and the use of the word electronic in the second sentence. And so it says that the skilled reader would look at those two sentences and say, now I can see, because it says alternatively and electronic, that it must mean a non-electronic, unchanging sign in the first sentence, and that is therefore disclosed. And we say that there are a number of problems with that contention. First of all, the text of both sentences uses the reference numerals from figures 2 and 3, where the reader knows that the graphical object is displayed on a computer screen. Indeed, there's obviously a reference earlier on to the computing apparatus 10 as well. The second problem is that the patentee has to read the word sign extremely narrowly. My learned friend, I think, said a couple of times, oh, well, it's the normal and natural meaning of the word sign. But we say not so, because the word sign actually has a wide meaning, in the sense that a sign is not just a placard or piece of paper. We understand the word sign to mean lots of different things. I mean, signs on the motorway that tell you that you're about to get to a traffic jam, which are changing. A digital open and closed sign on a shop. These are all natural and normal readings of sign. And so that the contrast that the appellant is trying to draw just simply isn't borne out by the normal meaning of the word sign. The other problem is that there is CGK, which the judge found in the case, that the skilled person would understand that barcodes can be displayed in a vast variety of ways. And that evidence is in the judgment at paragraph 65. So that's back in Core Bundle, tab 1, page 15. And it's paragraph 63 to 65, which essentially explains that you've got lots of different types of media on which you can display barcodes, anything from physical paper, labels, posters. It could be printed on the item itself and on billboards. And it could anything that could be displayed on a traditional computer monitor could be displayed on any other sort of electronic display. And at paragraph 65, what's explained is the vast array of different types of screens and displays that would be within the scope of the skilled person's CGK. So there could be digital poster banner-sized signs for indoor venues, smaller displays near doors, e-paper, LEDs, LCDs, any kind of technology essentially could be used for the purpose of the display. And we say that that is essentially what the judge is referring to at paragraph 174 of her judgment, which is at page 38. This is where she's talking about the two alternatives in the building security embodiment. And at the end, she refers to the fact that Dr. Birss gave unchallenged evidence that the skilled reader would understand sign in this context to relate to some kind of digital sign, including e-paper screens, LCDs or LEDs. And this evidence was consistent with the agreed CGK. Now, I accept that it might be said that the expert's view as to the meaning of a normal word, sign, wasn't strictly speaking relevant. But in my submission, what is relevant and what the judge is really doing here is pointing to the CGK as to the wide meaning or wide understanding that the skilled person would have as to how you could display a QR code in support of her reading of this passage of the building security embodiment, and that was a perfectly legitimate approach. Now, the next point in the building security embodiment, and this is important, is the third sentence, which comes just after the two we've looked at and starts at the end of line 18. In such embodiments, the encoded information may be periodically updated following receipt of signals from the first server apparatus. Now, the important thing to emphasise here is the fact that embodiments is plural. And in my submission, the only sensible way of understanding that sentence is that it refers to the two previous sentences, because those are two different embodiments, and that is why there is a reference to a plural embodiments and not embodiment in the singular. So what my learned friend has to say is that in such embodiments refers only to the immediately preceding sentence, because obviously his position is that the sentence about the display on a sign geographically proximate isn't something that can be updated. And so if the third sentence is referring to both of the two preceding sentences, then his interpretation of those two sentences must fail. And so we say that he can't get round the fact that there is a reference to a plural there. And indeed, the judge specifically dealt with this point at paragraphs 175 to 176 of her judgment, which is in Core Bundle, tab 1, page 39. And she explains that the claimant tried to submit that the alternative embodiment is a reference to a class of embodiments, which is why the third sentence is written in the plural. And she rejected that submission because she said there was no evidence to support the view that it related to a class, doesn't accord with the normal understanding of the text, and she agreed with our argument that it must follow that the sign is digital or electronic, albeit that it's different from an electronic display, and that the submission made by the claimant was circular. And in my submission, my learned friend hasn't adequately answered this important point about the correct construction of the building security embodiment, remembering that the patentee has to show that the static non-electronic sign is clearly and unambiguously disclosed in this passage. And in my submission, the use, at the very least, the use of a plural here means it's not clearly and unambiguously disclosed, in addition to the other reasons I've already given as to why it would not be clear to the reader. Remembering again, of course, that the reader is reading all of this in the context of the specification as a whole, which I've just been through, and it's all about computing apparatus and display and so on. The only way that you can get to the thinking that my learned friend wants us to adopt is if you are using hindsight and you're really squinting at it and saying, oh, maybe I can get it out of that passage somehow. It's not clear and unambiguous, and that is not good enough in this context.
Well, when I was reading it, trying not to adopt hindsight, one's quite simply understanding one's talking about an electronic door lock, and one sees that there is an alternative being suggested of an electronic display graphically proximate to the door lock. So when one then is reading a sign geographically proximate, what does the ordinary or skilled reader understand that to mean? Being geographically proximate to a door lock that's not an electronic display.
Well, it could be a variety of things. I mean, one thing it could be is something that's printed out, although then there's the difficulty with the third sentence, which is that it has to be periodically updated. Or one could understand it to mean one of these other types of LED or LCD displays, i.e. not something that if you give electronic a wide meaning, it might fall within that, but it might be telling the skilled reader that this is going to be an e-paper screen, an LCD or an LED. I mean, that was the view that the judge took in her paragraph 174.
But on, as I understand it, on your reading, it has to be something which can be periodically updated.
Yes, although, yes, following receipt of signals, indeed, following receipt of signals. But it's possible that you could have periodic updating following receipt of signals, even with something that's printed out. because you would send it to a sort of mini printer, which would be the computing apparatus, and it would print out a code, and then that would be changed when a new signal was sent. But really the key point here is I don't have to find a meaning for that sentence, because what I can say is that it doesn't clearly and unambiguously tell the reader that it is a static, non-electronic sign, because of the words in such embodiments, because of the wide meaning of sign, because of the reference numerals, because of the whole context. And again, you have to avoid hindsight.
Just look, this word electronic display doesn't appear anywhere else in the document, does it?
I don't think so, no.
No one's drawn it to my attention anyway. I mean, I wondered whether another way of looking at this is that sign, as the incautious and lacking in hindsight reader, the word sign is telling you essentially that it doesn't have any characteristics other than it signifies anything. It's not trying to be cleverer than that.
Yes.
And the word electronic is actually being used to distinguish from computer screens and talk about things like LEDs, because you could imagine an electronic door lock with a load of little LEDs on it, little lights, which could provide information that you could take a picture of. But you wouldn't call it a computer screen or a computer display.
Yes.
But I don't think, I mean, I'm putting that to you, but I don't think that's not the way the judge construed it, is it? Based on the evidence, she construed it the other way round, that it was LEDs that might be a sign rather than electronic that might be a sign. Rather than electronic might be LEDs.
My lord is right, but I mean the very fact that many legal minds have pored over this and have come up with various different interpretations does not bode well for a patentee who's got to show that there's only one way of interpreting this, and that the only way you can interpret it is that there is a physical paper sign. I mean, I'm not quite sure where my learned friend's construction has got to, but at one stage he seemed to be saying it had to be stuck on a wall. It clearly, as the judge said, it's clearly contrasting sign with electronic display, but that doesn't mean, this is earlier on in the paragraph 174 that we were just looking at on page 38. By contrast, yes, the bit that I was looking for was, as a result, whilst the skilled reader would appreciate that the patentee intended the concept of sign to be different in some way from that of electronic display, there is no reason why they would think that the sign will not be electronic. So, as I said earlier, it is also important that sign has this wide natural meaning. I don't accept that sign just means a piece of cardboard or paper. And again, I'm probably repeating myself now, but you are looking at this in the context of the whole of the rest of the specification, where you're being told it's all about computing and computer displays and things that you can update. Now, I just wanted to look at some additional points that were in my learning.
Sorry, Ms. Blaine, just to make sure I'm not missing.
Yes.
Is it right? It's necessary if the claim granted, if the claim in issue means by sign means non-electronic and unchanging from transaction to transaction. In order to avoid added subject matter, you have to find both.
Yes,
both
indeed.
Features.
Indeed.
Clearly and unambiguously derivable.
Yes, absolutely. Now, I just want to check that I haven't missed any points that my learned friend made either in his written or oral submissions. So I'm going to just turn to my skeleton argument, which is in the core bundle, tab 5 at page 122. I think I've probably made most of these points already. I'm starting at the bottom of that page, paragraph 32, and he prays in aid the fact that it's CGK that codes are commonly displayed statically. I accept that that is CGK, but I say the CGK is wider than that, as we've just looked at. So it's CGK that they're displayed in all types of ways, which is why we say that that doesn't assist, and indeed that the word sign could plainly cover both static and changing signs. And then it said that nothing in the claims of the application requires the encoded information to be dynamic. And we say, well, the problem with that is that you're ignoring all the other bits of the specification that I've shown already to my lords and my lady. And then a point was made, which I think hasn't been made orally, that the GO112 description says it comprises a geo address information item, which the claimant says is a hardware serial number, and that is, it said it's static, and therefore the sign must be static, I think is the point. But we say, well, that could change, and in any event, there's plenty of other information in the geo according to the patent. And then there are some very detailed points of linguistic analysis that were taken in the skeleton argument that my learned friend hasn't put forward orally, and we say they just don't add anything to the analysis that I've already made of these three sentences. So before I conclude on this added matter point, I just want to have a brief word about the smart tag embodiment, and I've already pointed out that my learned friend doesn't seem to be persisting with that argument, but in the context of that argument in his skeleton argument, and indeed in his oral submissions, my learned friend made a point that our expert, Dr. Birss, was wrongly instructed in how to approach the A and C specifications. And it's important that I point out that this point is actually wrong as a matter of fact, and in any event it's completely irrelevant. It's irrelevant because once informed of the CGK and the meaning of any technical terms, obviously it's a matter for the court itself to construe the A and C specifications, not the expert. Indeed, Dr. Birss didn't actually give any evidence at all on the meaning of the A specification. He didn't need to. And the meaning of the C specification is to be assumed in favour of the patentee in this case, in the sense that it is the meaning that was found by the judge. And it is also wrong to say that the judge made a finding that Dr. Birss had been wrongly instructed. She didn't do that. What she pointed out was that she said that my argument about things falling outside the scope of the claims in the C specification was not correct as a matter of law. But in fact, Dr. Birss explicitly considered the entirety of the C specification. He said that he thought the skilled person wouldn't be interested in parts of the C specification that were outside the scope of the said to be outside the scope of the claims, but he said explicitly in his first report at paragraph 6.2 that he had considered the entirety of the C specification. Sorry, that's a bit of a sort of aside and not key to my lords and my ladies' analysis of the added matter point, but it's just important that I set the record straight, because obviously we're a bit concerned on this side of the court that it's been said that our expert was wrongly instructed and there was a finding to that effect, when that is not actually the case. So in conclusion, we say that the real issue for the patentee here is the nature of the tests that my lords and my lady have to apply. That it has to be found, in order for the appellant to succeed on added matter, that this particular construction of sign can be clearly and unambiguously found in the A specification when you're reading it without hindsight. And in my submission, for the reasons that I've just gone through, that simply is not possible. It doesn't meet that high threshold. Now, moving on to extension of protection on the static display. The legal test there is even harder for the appellant, and I think it might be worth turning that up very briefly, even though I know at least one member of the court is extremely familiar with it. And that's in the authorities bundle at tab 3, page 122. And it's paragraphs 105 to 108 of Hospira and Genentech. And it points out that this rarely comes up at trial in the UK, no doubt because the law is clear and usually easy to apply. And the correct approach is to compare the scope of the claims as granted with the scope of the claims as proposed to be amended. And so just to be clear, what we're doing in this case is we're comparing the claims of the C specification with the claims actually of the B specification. So up till now we've been looking at the A specification. The claims as granted were the B specification, and then afterwards that was amended and became the C specification. And what you've got to do therefore is construe both sets of claims in accordance with the protocol, i.e. the correct approach for construction in patent cases. And we've already know how we should construe the C specification claims for this purpose. It's what the judge found. And then for the B specification, we have to do the claim construction. And the judgment goes on to say that usually to make the argument good, the person challenging the amendment needs to identify a concrete thing which did not fall within the scope as granted, but which would fall within the scope after amendment if the amendment was allowed. And it explains the purpose of the prohibition, which is the protection of the public, because once a patent has been granted, the public can rely on its scope and know that it will not get any wider by amendment. So the public has got to be able to look at the B specification when it's granted and say, can I do this thing that I want to do or not? And not be caught by a later amendment which changes the scope of the claim such that they then fall within it. Now, as it happens, there is not much difference between, or there's no relevant difference between the B specification and the A specification. So we don't need to do a great deal of extra work on this particular point. But you do have to do the work of construing the claim. You can't just say, well, can I find it somewhere in the specification? You have to find it in the claim itself once you've construed it properly. And my lords and my lady will have seen that somewhere in the judgment there's a long list of points that you have to apply when you're construing a patent. But there is also a helpful summary of the key considerations on construction, which I think my learned friend put in his skeleton argument, given by Lord Justice Arnold in Interdigital and Lenovo, which is you look at the wording of the relevant integer of the claim, secondly, the context provided by the specification, and thirdly, the inventor's purpose. So it's looked at in that way. Construing a patent is not too different from construing other legal documents: wording, purpose, and context. So if we turn to the judgment and see what the judge said about this point, which is in Core Bundle tab 1, page 42, paragraphs 195 to 200. And once again, she points out that the patentee relied on the building security embodiment. And she explains in relation to the building security embodiment that the text is a bit different in the B specification from the C specification, but actually it's the same pretty much as the A specification that we've just been looking at. And basically the points therefore are the same as those that we've just looked at in relation to added matter, and she therefore says at paragraph 197 that she rejects the claimant's argument that this passage teaches two alternative forms of display, one that is electronic and one that is not. And so that reasoning is exactly the same, and I rely on the same points that I relied on before. But even if I'm wrong about my reasoning, that doesn't mean that I would fail on this extension of protection point, because ultimately you've got to construe the claims of the patent. So we've got that is the first point. The second point is the point that is covered at paragraphs 198 to 199 of the judgment. And that is some wording which is set out, she says, at page 2, lines 15 to 17, which says preferably the decoded information item. Sorry, the decoded information includes an apparatus identification item allowing identification of computer apparatus on, by, or near to which the encoded information object is provided. And the real issue here is that it doesn't shed any light, this wording, on the meaning of the display. Just because it can be by or near doesn't mean that it's non-electronic or static. And moreover, when you get to the claim, as the judge points out in paragraph 200, which is her third reason, the skilled reader is told that you're obtaining a graphical encoded information item which is displayed on a display of a computing apparatus. And we say that claim wording is absolutely decisive for this extension of protection point. Because in addition to the context, which I've already gone through, of the whole specification, which you obviously need to look at for the purpose of construing the claims, and which all relates to computing apparatus, you have to look at the wording of the claims, and that is telling you very clearly that the geo is displayed on the display of a computing apparatus. And so that makes plain that the geo is not a non-electronic static thing. And the judge points out that at the end of paragraph 200, this is the natural reading of the integer. It's consistent with the teaching of the document. If the skilled reader thought that the building security embodiment where the geo is displayed on a sign related to something that was not electronic, which I do not believe they would simply conclude that the patentee had excluded that option from the scope of the claims. Because there may be lots of different embodiments in a patent specification, but they're not necessarily always all claimed, and so you may have embodiments which are then not in the claims. So we say that the appellant simply has no answer to this point, because the skilled person reading the claims of the B specification are going to think that they are safe from infringing this patent if they use a static non-digital sign. In other words, if they use something which is not displayed on the display of a computing apparatus. And indeed, as per paragraph 107 of Hospira and Genente we've just looked at, the defendant in this case can identify something that previously didn't fall within the scope of the claims, namely a QR code displayed on a piece of paper or card, that following amendment on the judge's construction doesn't fall within the claims. Rather, it would fall within the claims now, but didn't fall within the claims previously. And indeed, it's the very thing which is said to infringe in this case. So I don't know whether my lords and my lady have focused on paragraph 3 of this judgment, which talks about the alleged infringement in this case. That's outlined at paragraph 3. infringement is no longer an issue, but one of the steps of the different types of the system that were in issue at trial require the user to scan a QR code that is displayed on a piece of paper or card that has been attached on or near the petrol pump. So my client, looking at the B specification, would think, it's okay, I can do this because it's not displayed on the display of a computing apparatus. But of course, on the construction of the learned judge on the C specification, they can't do that because that covers a static non-electronic sign. And we say that is where there has been an extension of protection in the scope of the claims. And we say that is why this patent must be invalidated on the basis of extension of protection. So I'm now going to turn to the other added matter point, unless my lords or my lady have any questions about the static sign point.
Thank you.
Now, staying with the judgment at paragraph 164, which is on page 36 of the core bundle, you can see set out here the changes between the application as filed and the C specification. So we're talking about added matter again here. So we're back to the test of, can you find it clearly and unambiguously in the specification without hindsight? And rather than talking now about the meaning of display and sign and so on, what we're focusing on is that in the C specification, the term electronic apparatus has been added in 3 places. So first of all, it's been added in the first bit of underlined text, wherein the computing apparatus comprises the display and an electronic apparatus, and wherein the display is a sign. And then at the end of the claim, you can see that there's an amendment to the penultimate integer. So instead of saying providing the service to the user via the computing apparatus, the amendment now says using the apparatus identification information item to transmit a signal to the electronic apparatus, and the electronic apparatus providing the service to the user. So the 2 bits we're focusing on in this added matter argument are actually both the bits at the end. So it's the apparatus identification information item, which I'm afraid is a bit of a mouthful, is used to transmit a signal to the electronic apparatus. And then the final integer, that it's the electronic apparatus that provides the service to the user. Now, we need to again look at the A specification in a little bit of detail to see what that tells us about this point about the apparatus identification information item and the provision of the service. So going back to the supplementary bundle at tab 2, page 25, because we're back now in the A specification, I need to highlight some, sorry, I think that's a wrong reference. It should be page 52. I need to highlight some particular parts of the specification that discuss this. So starting at page 52, lines 6 to 24 discuss what happens in terms of providing the service, and it's divided up into paragraphs. The first paragraph essentially is dealing with the fact that the first server apparatus, which is referred to at line 8, compares the verification information item with a reference item and basically verifies that this person is able to use the service, essentially, paraphrasing somewhat. And if there has been that verification, then what happens is that the decoded information item. The decoded information included an apparatus identification item, which allowed for the identification of the computing apparatus, which is where you've then got the graphical object provided. And what happens is next is that you send a signal or a signal is sent to the computing apparatus based on that apparatus identification information item. And then next at line 23, the action is performed, and that comprises allowing the user to access a service, and the signal comprises an indication that the user is allowed to access the service. So the signal which is sent to the computing apparatus using the apparatus identification item, information item, allows the user to access the service, provided they've been verified as per the second paragraph on that page. So the user is basically authorised to access the service. I mean, I'm afraid it's in patentese, so it's not crystal clear. But the thing to notice is obviously what the apparatus identification information item is doing, and how the user is being allowed to access the service, and that's by the sending of the signal to the computing apparatus.
So, trying to put this into human being
Yes.
speech, is it right that what's going on is it's the server that's using the apparatus identification information
Yes.
in order to work out what piece of apparatus to send the message to,
Yes.
to tell the so-called computing apparatus,
Yes.
which is the local thing that they can let the user use.
Yes. Yes.
That's what's happening.
Yes.
So the entity that's using the apparatus identification information item, as it's called, is the server.
Yes.
And it's not sending that apparatus identification information item to the local computer. It's using it as the address of the local computer.
Yes, indeed.
To work out who it's
Yes.
supposed to be sending a message to.
Yes. Exactly.
Okay.
And you've got some similar text on page 56, which is at lines 1 to 12, where it's in a slightly more condensed form, perhaps easier to understand, I don't know. But this is talking actually about the second server apparatus. But again, making clear that the apparatus identification information item, which is referred to in the first two lines, allows for identification of the computing apparatus. And the second server responds to the receipt of the second message by sending a signal to the computing apparatus based on the apparatus identification information item. And then the second server is configured to respond to the receipt of the second message by allowing the user to access a service. So it's authorising access to the service. And then at page 63, you've got some slightly shorter references to provision of the service. First of all, at lines 21 to 23, where it says the user of the device must register with the first server apparatus to allow the user to utilise the service provided by the first server apparatus. And then on page 65 at the bottom, lines 31 to 33, where it's the second server apparatus which is providing the service. So the user is authorised to access the service provided by the second server apparatus. And then at page 74, where you've got the ATM embodiment, at lines 19 to 22, the first server apparatus, which is in this example associated with the banking establishment, authorises the withdrawal and debits the user's account by the amount indicated by withdrawal and by the withdrawal amount information. So it authorises the withdrawal to take place. And then if we go to the claims, which are at page 80, you've got the reference at lines 11 to 13 to the apparatus identification information item for allowing identification of the computing apparatus. And then at lines 19 to 22, you've got, in response to establishing the identity of the user, authorising the user to access the service and providing the service to the user via the computing apparatus using the apparatus identification item. So obviously...
Sorry, Ms. Lane, just looking at that claim,
Yep.
looking at the whole thing, it's structured in such a way, isn't it, that if you start at the beginning, it says a method comprising, and then there's a colon, and then there's a portable device, and then a colon, and then there is 1, 2, 3 indented paragraphs, which are all characteristics of something that the portable device does.
Yes.
Yeah. Then at line 14, there's a first server apparatus,
Yes.
the colon, and then there are 3 things that does: receiving, establishing, and in response to. And then the providing, there's a colon at the end of line 20, and the providing the service is actually a 4th thing, isn't it? Is that right?
Well, I mean, the colon's in a slightly odd place, isn't it?
Server, do you?
Pardon?
You say that providing is an action carried out by the first server apparatus rather than by the method.
Well, it's carried out by the via the computing apparatus.
Mm-hmm.
I mean, that's what it says
Right.
in the last integer.
Yes. So, but the reason I'm pulling you up is that, as I understood your submission before, you sounded like, and maybe you didn't mean this, but it sounded like you were reading that last clause, providing the service, as being something which was underneath the first server apparatus colon does.
No, I wasn't
Okay.
intentionally doing that.
I see. Because what I was suggesting is that it doesn't seem to be how it's structured.
No.
So for the that 4th thing is a 4th separate thing. And
Yes,
your
but
point
it's
is
got
that
to
it's
use the
provided via
apparatus.
the computing apparatus.
But it has got to use the apparatus identification item,
Yes.
which is referred to earlier on, which identifies the computing apparatus.
Yes. But how does the computing apparatus being the local computer, how does it use its own address to provide the service? Because I thought what you showed us before was that it was the server that was using the apparatus address, the apparatus identification item. It was the server that was using the address to send a message to the local computer.
Yes,
What
exactly.
you seem to be saying now is it's the local computer that's
No.
using its own address. No, you don't mean that.
No, I don't mean that, my lord, and
Okay.
it is tricky, and so I'm probably not explaining myself very well. But the point is that in order to get the signal to the computing apparatus to tell it to provide the service, you have to use the apparatus identification information item.
Yes. No, I get that. I think putting it in my, without being overly grammatical, the actor of the verb providing in this claim and that bit is actually the method. It's the method that provides the service to the user via the computing apparatus using the apparatus identification item. We know the computing apparatus doesn't use the apparatus identification item. So
No, it's the method, exactly.
Something else must be, and it's the method.
Yes, it's
in
the
this
method.
language.
Yes.
It seems to me it's just an overall summary of what's happening. Isn't it?
Right.
Yes, indeed. But
Yes.
what it is making clear to the skilled person is that it's the computing apparatus that authorises the user to access the service, having been identified by the apparatus identification information item.
Okay, I thought you thought the server rather than the computing apparatus was authorised.
Well, I think the server can be part of the computing apparatus.
I think that may be what isn't one reading at least, providing the service to the user via the computing apparatus, and then stop using the apparatus identification information. So it's the service is being provided via the computing apparatus, and the key thing about this method is that it's using the apparatus identification information.
Yes, because a message has to be sent from the first server to the computing apparatus,
Yes.
using the apparatus identification information item.
Mm-hmm.
So what we need to do now is look at the building security embodiment, because that's where so just to be clear, obviously this doesn't have within it the things that we were looking at in the, perhaps it would be helpful to look back at this again in the judgment of paragraph 164, which helpfully sets out the amended version of the claim. So if we look again at the last two integers, the apparatus identification item is used to transmit a signal to the electronic apparatus, not the computing apparatus, and it's the electronic apparatus that provides the service to the user. And so obviously the electronic apparatus hasn't been mentioned in the original version of the claim. And we now need to go to the building security embodiment, because that's where my learned friend seeks to get the electronic apparatus from, remembering again that it's got to be clearly and unambiguously identified without hindsight. And we've got to look here at the second half of this building security embodiment, which is at the bottom of page 72. And I'm going to pick it up at line 22. The end of that line says the encoded information item may also include an FSID information item, and that is a first server ID information item, and we can see that back on page 68 at line 11. And upon approaching the door, a user uses their mobile device to obtain and decode the encoded information item. Subsequently, optionally, following the successful provision of security information by the user to the mobile device, a first message, including the geo address information object item and the UID or DID information item, is sent to the first server apparatus. In this example, the first message comprises an entry request. In response to receiving the entry request, the first server apparatus establishes the identity of the user, so that's the sort of verification step. And next, if the system does not comprise the second server apparatus, the first server apparatus transmits the signal to the electronic door lock using the geo address information item, authorising the electronic door lock to open and thereby to allow the user to pass through the door. And we say that this is consistent with what is in the claims. In other words, that the first server, the FSID information item, is the apparatus identification information item, and that is the thing that is being used once verification has been conducted to tell the system that the person can be authorised to enter, and the reference to the signal to the electronic door lock is is something that is completely consistent with saying this person is now being authorised to enter, and so obviously a signal is needs to be sent to do that, but that is a separate thing from the signal that is being spoken about in the remainder of the description and in the claims.
So, Rosaline, you said the FSID item is the apparatus information item.
Yes.
Isn't that's not the address of the door lock, that's the address of the server.
Exactly, yes.
Right. But do you mean that, are you saying that the last line of page, whatever it is, the bottom of page 72, where it says using the geo address information item, that is the FSID thing?
No, that's something different.
Because that geo address information, I think, is the electronic door locks.
Yes, it is. It is, yes.
I'm confused, I'm afraid.
Well, I mean, I have to say this is all very confusing, but that is not a good basis on which to show that something is clearly and unambiguously disclosed in the specification.
That's not what I meant, Ms. Lane, actually. I mean, I don't understand your submission.
Well, perhaps it would help if we looked at what the judge said, because she may have put it better than I did.
Okay.
So that's in the core bundle at page 41, paragraph 187. So she says that the amendment to the claim which provides that the computing apparatus comprises the display and the electronic apparatus does not add matter, since this is consistent with how the skilled reader would understand that term in any event. I do not think that describing the business end of the computing apparatus as electronic apparatus changes the disclosure or provides new teaching. However, I consider that the additional final integer, which requires that it is the electronic apparatus which provides the service to the user, is new disclosure, which changes the way the invention works. I do not agree that the passage the claimant relies upon, as quoted directly above, provides support for this amendment. To the contrary, that passage is consistent with the teaching set out in paragraph 185 above, to the effect that it is the server that provides the service to the user by authorising the door to open, and not the electronic door itself. So what she is saying is that if you read the building security embodiment, consistent with the rest of the parts of the specification that we looked at, the provision of the service by the computing apparatus is effectively the authorisation of the user by sending the signal saying the user can now get the money out of the ATM, or the user can now enter through the door. It is not the further additional step of a signal being sent, in this case, to the electronic door lock. And so we say that that is entirely...
Sorry, forgive me. Does it come to this, that the point is that what the judge is deciding is that what was disclosed was that it was the server that was providing the service, because the service the server was providing was to authorise access.
Yes.
Whereas what the claim now claims is as if it's the door lock
Yes.
that's authorising the access. But
Yes.
it's not. The door lock's been authorised by the server.
Yes.
But the service that the claim was talking about was the authorisation by the server, not the opening of the door by the door lock.
Yes, exactly.
That's what you mean.
Yes.
And that's what
yes.
that's what the judge held.
Yes, indeed, indeed. And I mean, it's fair to say that I'm afraid the specification, as we, what I've done is taken my lords and my lady through the various passages in the patent specification, which are not entirely clear, and indeed they're slightly inconsistent, because in some places they talk about the server doing something, in some places they talk about the computing apparatus doing something. But in all instances, in my submission, what was clear from the passages we looked at was the service was the authorisation of doing something by the computing apparatus.
I don't think it is providing the authorization is it's providing the service. And the definition, we have the user. And what is the user doing? The user is using the service. And what the original wording was that using the apparatus identification information item, the computer apparatus provide the service to the user, i.e. access to the website service. And this is now changed to the electronic apparatus provides the service to the user. It seems to me what's happened is it's changed computing apparatus to electronic apparatus, which is exactly the switch that the judge didn't seem to have a problem with.
Well, she didn't have a problem with it in the first part of the claim, because she said that a computing apparatus could comprise the display and electronic apparatus, and that was something that was made clear in the building security embodiment. But the difficulty she had was with the latter parts, the final two parts of the claim, where the service is said to be provided by the electronic apparatus. And she said that that wasn't clearly and unambiguously disclosed by the specification. Because looking at the building security embodiment, there are sort of two readings that you can have of the building security embodiment. One reading is that it's the electronic door lock providing the service, but the other reading is that it's the service is being provided by the computing apparatus authorising the electronic door lock. And because you've got to show that it's disclosed clearly and unambiguously, two readings isn't good enough for the other side. They've got to show that it's clearly and unambiguously one reading only.
Well, what about this? If you start from the granted claim, the B specification claim, and change the word computing in computing apparatus in this phrase to electronic, that wouldn't be added. That wouldn't be a added subject matter. The judge has said so. If you take the claim as granted, and the last words say providing the service to the user via the computing apparatus using the apparatus, take that and change the word computing to electronic.
Yes.
The judge has said that doesn't. She's not focusing on that because I'm
Yes.
making this up. But
Yes.
she doesn't think that adds subject matter. Then what might be said is that all that's happened is that they've rearranged the phrasing there to separate out the use of the apparatus identification item, which is something which I don't think is used by the electronic apparatus.
Indeed.
It's used by the server.
Yes.
From the thing which actually the service is provided via, and the service is provided via the electronic apparatus. All they've done is rearrange the words a bit. It doesn't mean anything any different. Why is that wrong?
Well, I think there are two separate points that need to be taken into account. One is the fact that they've added in the electronic apparatus, but also, in my submission, they have changed the meaning of the apparatus identification information item, because that is the thing that allows identification of the computing apparatus according to the earlier part of the claim, so that the bit that starts transmitting a first message to the first server apparatus.
Just on that submission, I don't recall the judge gave that as a reason. If I've missed it, please tell me. Where do you say the judge had decided that they changed the meaning of apparatus identification item?
Well,
I don't recall reading it.
I'm just trying to find the relevant part of the judgment, because she does talk about the fact at paragraph 185 that we submitted. So if you look at paragraph 185, about 5 lines down, the defendant submitted that this teaches that the apparatus identification information item is transmitted to the computing apparatus and not the electronic apparatus. They also pointed to the fact, etc. So in my submission, she is accepting that in her paragraph 187, albeit that the reasoning isn't extensive.
Okay, thank you.
So, I mean, essentially, I think I've covered the points that I wanted to on this. We, as I've already said probably too many times now, rely on the fact that it has to be disclosed clearly and unambiguously and without hindsight again. And we say that that isn't clearly and unambiguously disclosed in the building security embodiment. So I was planning to move on to obviousness now, unless there are any questions on that part of my submissions.
Yes, thank you.
So, as my learned friend has already said, there's no dispute on the law in relation to obviousness. And there can be no dispute on the fact that an appellate court, as I'm sure my lords and my lady are very well aware, must be very cautious to interfere with a decision on obviousness, because it's an evaluative decision which weighs numerous factors, including, of course, the judge's assessment of the two experts' evidence, who she has obviously had a chance to hear and watch giving their evidence. And that's something that my lords and my lady will be well aware of and keeping in mind all the time, every day of the week, no doubt, in this court.
Comes up quite a lot.
So the way that the appellant approaches Schmidt is to say that it's mainly about payment in a taxi. And the reason it takes this approach is because that helps with its theory that the price of the service, and therefore the barcode, must change between transactions and therefore cannot be static. And we say that actually if one looks at Schmidt, the teaching of Schmidt is much more general. And I know my learned friend has already taken you to this, but I just want to look at a couple of points in the Schmidt specification to make good that the teaching is general. Starting with pages 5 and 6, so we're in supplemental bundle tab 1. And at the top of that page 5, it talks about when paying for a ticket for parking or a ticket for inner city public transport, cash is often still necessary. In the current era of otherwise highly acceptable cashless transactions, this problem is not known to many business travellers or tourists who assume that the availability of cashless payment options and accordingly carry only little cash. So we're talking about payments generally here. And at the bottom of the page, lines 18 to 21, the present invention accordingly increases the acceptance of cashless payment means among the service providers or merchants and reduces the installation costs and running costs. So it's clear that it's talking generally about payment. And over the page on line 6, it says in one embodiment of the invention, coded data are communicated from a terminal to a central server by means of a mobile terminal device. And for this purpose, the terminal generates data containing information regarding payment. The data are coded into a multidimensional barcode. Said multidimensional barcode is retrieved from the terminal by the mobile terminal device. And so we say that it's clear from all of that we're talking about payments of for lots of different types of goods and services. It's not limited in any way to something that must necessarily change between transactions. And in particular, when we look at figure 2, which is described on pages 7 to 10, I'm not going to go through all of that, but if we look at page 10, line 4, it says figure 2 represents an exemplary system in accordance with one embodiment of the invention. And this system enables, as an example, the cashless payment for services and or goods. So it is perfectly general. And it then talks at lines 19 to 23 about the terminal can be a taximeter, a ticket machine for parking, a checkout in a supermarket, part of a fuel dispensing pump at a filling station, or an arbitrary device for determining fees for a service or the value of goods. And on page 13, it makes clear that the barcode can be shown on a terminal or printed out on a sheet of paper, and that's lines 15 to 19, which says in an alternative embodiments the multi-dimensional barcode is printed out on a sheet of paper by means of the printer unit. And then sometimes it goes on to say you can have a terminal can have a printer unit and a display. And figure 3, which my learned friend took you to, is a page 46. That's the last page of this tab. And again, we say this figure, and in particular step 305 and 325, both of which I think my learned friend referred to, which talk about generating data and creating a multidimensional barcode, are perfectly general and do not require that there be a new barcode for every transaction. Now, as my learned friend also explained, Schmidt contains practical scenarios in which the system and method of figures 2 and 3 can be employed. And so one of those, as we've already looked at, is the taxi cab embodiment, which starts at the bottom of page 29. And the other is the local public transport scenario, which is what we're concerned with in the appeal. And that is starts at page 32. And it's worth looking at this particular scenario in a little more detail. So the first part talks about, at the stop of the LPT, there are multi-dimensional barcodes depending on the line of the local transport, and it explains what would be contained or might be contained within the barcodes, and the fact that the passenger can photograph them. And then it goes on to say, at line 15, in other embodiments of this example, a ticket machine for travelling is installed at the stop of the LPT, said ticket machine having a display on which, depending on the selection of the route, a multi-dimensional barcode appropriate to the selected route is then displayed. And then further down at line 22, in a similar manner to the previous embodiments, the ticket machine for travelling can also have a printer unit which then prints the multi-dimensional barcode on paper, whereupon this can be photographed or scanned in using a cellular phone having photographic capability. And then over the page at line 9, the payment operation is concluded and the passenger can enter the means of transport. And so we say that it's clear from the first part of this scenario that the sign can be a static sign for a single line. I mean, that's what it's talking about there, multi-dimensional barcodes depending on the line of the local public transport. And also, in the second example, the sign can be printed on paper. And so we say that the appellant is wrong to say that this embodiment is on its face an implementation of a dynamic, not a static barcode. I mean, I'll come in a minute to the judge's finding, and she found that it simply isn't clear, that there's no express teaching that the barcode must change with every transaction, and that is absolutely consistent with what we've seen there in that passage about the LPT scenario. And we also point out at this stage, by way of introduction, a couple of things about the LPT scenario which I'll come back to. There's a suggestion from the other side that this scenario is sort of somehow split into two, and so you look at the first part, lines 4 to 15, separately from the second part. That is not consistent with what my expert, Dr. Birss, said, and we may look at that cross-examination briefly. And it's also not right, and again we'll probably look at this bit of cross-examination, time permitting, that Dr. Barisso described the LPT embodiment as almost tripping on itself. I mean, we've already looked at that passage of cross-examination, but we jumped over the key words. Dr. Barisso's complaint was that patents generally almost trip on themselves. He said that that was a problem with all the patents he'd looked at. He was not particularly calling this one out as being unclear. So we now need to look, having briefly looked at Schmidt itself, look at the judge's findings on Schmidt at, in the judgment, core bundle, tab 48. Sorry, page 48, tab 1. And I'm going to start with the judge's findings on the teaching of Schmidt. That's in the anticipation section of the judgment, but the judge does go back to rely on it in the context of obviousness itself, and for that reason it's important. And in particular, I would ask my lords and my lady to look at paragraph 224, where she found that I do not accept that Schmidt teaches that the barcode must be dynamic in the sense that it must change for each individual transaction or every time the system is used. There's no express teaching in Schmidt to the effect that the barcode must be different with every transaction. Whether or not that is the case will depend on the nature of the service in question. So obviously she goes on to say it will be like that for a taxi meter. That's not necessarily the case for the LPT embodiment, where, for example, the same barcode could be used by different passengers for the same journey on a particular line. Moreover, there's nothing about the purpose of the invention disclosed in Schmidt which requires the transaction to change every time the system is used. And so that is a big division between myself and my learned friend as to where you start from in Schmidt. My learned friend wants to start from a place where he says, oh, well, Schmidt, it's all about taxis and it's got to change every time. And we say, no, that's not right. And the judge held that that's not right. And indeed, consistent with what we've just looked at, that is not right. So there's no express teaching that it must change for every transaction. And that was a matter for the judge to decide once she had been educated as to the common general knowledge. And indeed, I've cited an authority which makes clear, an authority of this court, Optis and Apple, at paragraph 133, that makes it clear that it is a matter for the court to decide, having been educated as to the CGK, what the meaning of a technical document is. And I might just turn that up very briefly. It's in tab 6 of the authorities bundle at paragraph 133. So what was held there was that the interpretation of NRC3, as with any other technical document, is a question for the court once educated as to the identity and attributes of the skilled person through whose eyes the document is to be read and as to their common general knowledge. Expert evidence is admissible and usually essential to assist the court to understand those matters, but it's not admissible, let alone determinative, as to the meaning of the document. And then it goes on to say, it is of course true that expert evidence is also admissible and often vital on the question of what the skilled person would think and do after reading the document, but that is a separate question. And so that's an important passage for the purpose of this appeal. First of all, because it tells you that the judge was perfectly able to draw the conclusion that she did about what was taught by Schmidt, but also that when it comes to the question of obviousness, which is the question of what the skilled person would do after reading the document, that is a matter on which you need to look at the expert evidence. And so, looking at the expert evidence, we have first of all the evidence of Professor Martin, which the judge relied upon at paragraph 240 of the judgment. And this is where she comes on. We've just been looking at the anticipation section of her judgment. We're now coming along to look at the obviousness section. And she essentially has three reasons why she accepted our case on obviousness, which was that it would be obvious to implement the ticket machine scenario using a barcode that didn't change between transactions. And the first was the evidence of Professor Martin. And she extracts some of the passage there at paragraph 240 and points out that the claimant had criticised this cross-examination and said it was based on the ingenuity of counsel and that it was unclear what was being put to the witness. But she says, in her position as trial judge, able to watch the cross-examination, she believed that the professor understood what was being put to him, and she said it's illustrated by that particular exchange. And in my submission, if we turn up the cross-examination briefly, which is in the supplemental bundle tab 5, at page 184, the bit of the cross-examination that is extracted by the judge is the bit that's on page 239. But in fact, the cross-examination on obviousness starts really at the bottom of page 237. And I'm not going to go through it all now. Time doesn't really permit, but what I do want to point out is that if my lords and my lady read from the bottom of page 237 all the way through to halfway through page 242, that is all of a piece with the section that is extracted into the judgment. And I would particularly point my lords and my lady to page 241, line 14. The question is, there are many options. Some people would choose a different option, but there would definitely be some skilled people in your category of the skilled person who would do it in the way I have just described. Okay, it is possible, yes, they would do it in that way, some of them, if you say so. You're asking me something I do not think I can answer. What you're proposing is not crazy, but it does not follow automatically from what is written here. I say I will give it one last go. It's a methodology that some people, skilled people, would adopt if they were implementing this. Well, again, I'm uncomfortable because I do not think we have a full description. So I think that the proposal you're making is a solution in some interpretation and a fairly simple interpretation of what is being proposed here. And I say so in certain simple local public transport systems, that would be a sensible way to proceed. With a very simple ticketing system in place, flat fares and things, yes. But is it sensible in that setting? Maybe. So, my Lord Justice Birss will be well aware of the fact that when you're cross-examining an expert in a patent case, it's a complete miracle if they actually agree that it's obvious. I mean, that very rarely happens. So what you're looking at is whether the expert is agreeing that it's something that they could do, whether they're providing good reasons or not very good reasons in support of what they're saying. I mean, there's always this point that is run by the patentee, which is they say, well, you didn't get the expert to agree that they would do it as opposed to they could do it. And we say that's something that the judge had well in mind if we look at the last part of the paragraph 239, where the judge says that it was put to Professor Martin in cross-examination. He agreed that this was one possible option for implementation, although he pointed out that there were other ways in which it could be done. So she was well aware of this point about could, would. And we have to take a step back here and think about what it is, this gap, this step that has to be taken from what is in Schmidt to what is in the claim. And essentially, in the local public transport embodiment or scenario, we have a ticket machine. We have a ticket machine which is printing out barcodes. I mean, it says that. And so the step that the skilled person has to take to the claim, it is a step where the printed out barcode doesn't change every time. So it really is a tiny step. It's not rocket science. This isn't some amazingly complex piece of technology. And I'm afraid it wasn't based on the ingenuity of counsel at all, this bit of cross-examination. It was based on Dr. Barisso's evidence, which I will come to in a minute. So we say that the judge was perfectly entitled to take the view that she did of Professor Martin's cross-examination and say that he agreed that this was a perfectly sensible and obvious way of implementing the LPT embodiment. And the second reason that she then moves on to at paragraph 241 in support of her finding on obviousness is that what Professor Martin said was consistent with the observation that she made above at paragraph 224, which we've just looked at. And that's the paragraph where he said, sorry, where she found that there was nothing in Schmidt that taught that the barcode had to be dynamic. In other words, there was no express teaching that it had to be different with every transaction. And as she said at paragraph 224, whether or not that's the case will depend on the nature of the service in question. And so that is all consistent with what is being said by Professor Martin at paragraph 240. And she also goes on to say, and this is her third reason for the finding of obviousness at paragraph 241, was that she accepted the unchallenged evidence of Dr. Barisso that this would be a simple design choice. And in relation to that, I think perhaps we do need to turn up Dr. Barisso's evidence very briefly. I think we have already looked at it, but it's in the, well, I'm calling it the unagreed bundle, the additional bundle, and it's in tab, well, it's page 91, that's probably the easiest, but page 91 is the start of his second report, and then we need to turn to page 102. And just to explain and give a little bit of background as to how the evidence came about like this, actually pretty much prior to trial, but certainly prior to the service of the first expert report, we didn't actually understand the construction that the other side was running. And so rather like my Lord Justice Birss before the short adjournment, we thought that what was being said was that a sign had to be printed out on a piece of paper, or that would fall within the definition of sign. We didn't understand that the additional point was also being taken that it had to be unchanging. And so that's why when we come to look at the expert evidence, the first report of Dr. Barisso doesn't really address this in a lot of detail. In fact, it doesn't address it. So we then come to the second report, and I think it's perhaps worth starting at paragraph 7.2, because he there says, if I'm wrong about the above and a static sign is not disclosed in the case of Killicotte and Schmidt, then in my view the skilled person would regard it as obvious for a static sign to be deployed to display the barcode in some of the various uses disclosed in the prior art. And he explains the reasons for that, and that's because, as we've already looked at, the CGK shows that you can display it in lots of different ways, including printing them on paper or other physical medium. And that's how they were first used, indeed, barcodes. And then he goes on to explain how implementing the methods disclosed in the prior art, which is Killicotte and Schmidt, is largely a matter of what is going to be contained in the barcode and what the overall use case for the system is going to be as to how, basically, how you display it. And that is why he says at the end of that paragraph then it's a simple design choice, because you could have it on a screen, or it may be more convenient for it to be printed on a piece of paper. And he then goes on to say at paragraph 7.4d, specifically responding to Professor Martin's evidence, in determining that Schmidt only requires dynamic data, Martin is clearly ignoring Schmidt's assertion that printed barcodes could be used, and he explains that Professor Martin hadn't said that it would be surprising to see the use of static information, and he said, I agree with that, it would have been obvious. So he clearly sets out the stall on obviousness here, and that was his written evidence, which the learned judge said at paragraph 241 was not challenged. Now, my learned friend disputes that. I should perhaps also ask, before I turn over and go to something else, I perhaps should also ask my lords and my lady to read paragraphs 8.2 to 8.4, which is some more discussion about the use of different types of sign, just to give some more context. And so the evidence that the judge had in mind in my submission at paragraph 241 was this evidence at paragraph 7.3, a simple design choice. We say that this wasn't adequately challenged in cross-examination. She was right to find that it wasn't challenged. And that's because if you look at the evidence of Dr. Birss, which is in the supplemental bundle at tab 6, to page 246. Actually, I think it might be worth starting at page 245. And again, I don't think I've got time to go through absolutely all of this. But if we start on page 245 and transcript page 388, you'll see that what's going on there is that my opponent is putting that the text is very unclear because it doesn't tell you after you get to the middle of line 15. That's what the other side called the first part of it, that the data, what further steps happen to the data or what the user does with it or whatever. So this is my learned friend's point, that it's divided into two sections. And Dr. Birss says, I suppose it could be read that way. And then he goes on to say, I probably continue to read it as there being an interruption in the thought process of this embodiment, in which it is saying, hey, we are doing it this way, there is an option to do it another way, and it basically reverts back to the continuation of the flowchart on figure 3, more or less. And then there's a question about whether you have a terminal device in lines 4 to 15. And Dr. Birss says, yes, and I agree, it does not explicitly say it there, but I would imagine that the people drafting the patent and the average skilled reader would assume that any of the options, there could be a terminal there, could be a sticker label with the information there, it could be electronic display. It is just saying, hey, you can have a barcode with the appropriate information at the local public transport station, and here is how you would potentially then process through it. And just moving on now to the bottom of page 389, which is the passage where Dr. Birss says that in all of the patents it's all a little confusing and almost trips on itself. And then there is the cross-examination at page 390, which relates to middle of the page, line 14. If we restrict ourselves to lines 4 through 15, I agree that there is nothing there that explicitly would allow me to do static because of the data validity component. He goes on to say it would require a lot more work. But that is because he's talking about something that has to have the date of validity component in it. So that's the specific reason he's saying it would be difficult there. He's not saying generally it would be difficult to make the choice to have it as a static sign. And then it goes on, and we've already looked at this part on page 391, to the questioning about scanning line 14. You're scanning something that in effect defines a ticket price. You pay for it via a central server. Correct, I agree. But the barcode you are scanning there is no computer apparatus on or near it in the assumption I put to you. It depends on whether or not, if it is a sticker iteration, then you are correct. And that is just a reference. I mean, we were looking at that prior to the short adjournment, and that is all a reference back to the discussion earlier about there being different ways of doing it and whether you were restricted to just reading lines 4 to 15 on their own, which Dr. Birss disagreed with. So it is true that there was some cross-examination on the passage in Schmidt that we've been concentrating on. But in my submission, what was not challenged was the general statements that we've looked at in paragraph 7.3 and the subsequent paragraph, where Dr. Birss was explaining that it's essentially a simple design choice to have a static, unchanging barcode as opposed to an electronic display. And so we say, on that basis, there was ample reason for the judge to find that the patent was obvious over Schmidt. My learned friend hasn't done enough to impugn the decision on the basis that this is an overall evaluative assessment where the judge clearly looked at the document itself and her conclusions on that, the evidence of both the experts and her conclusion, having seen them give evidence orally. And on that basis, we say that this simply doesn't cross the high threshold needed to challenge a decision on obviousness.
Ms. Lane, can I want to make sure I'm not misunderstanding something. What I'm trying to put in my mind is a picture of what it is that you were saying was obvious, which the judge seems to have concluded was obvious. And I start from 239, where the judge says, as regards the LPT, so para 239 is the judgment. As regards the LPT embodiment, the defendants argued it would be obvious to the skilled reader to implement the ticket machine scenario using a barcode which didn't change between transactions.
Yes.
So that was the case, and as I understand it, you say, and I think you're right, that that's what the judge has found was indeed obvious.
Yes.
Now, there are two ways in my mind that I could imagine one might do that, and it's not clear to me whether they were both there, or one or the other of them, or what. And what I'm talking about is this. What I thought you said earlier on was that what was obvious to do was that scenario, a ticket machine using a barcode which doesn't change, in which effectively you've got a ticket machine with a printer, as you say there's printers in Schmidt, ticket machines with printers.
Yes.
And the user comes up to buy a ticket, and,
yes.
And the ticket machine prints out a new barcode every time a person comes.
Yes.
For example, if it's the same day and it's an adult and it's the same tube line,
yes.
The barcode is in fact the same barcode.
Yes.
Between user 1 and user 2.
Yes.
And that's one kind of way in which the barcode is unchanging, and you say if they do that, that's within the claim of the patent.
Yes.
But the other scenario is something to do with sticking barcodes on the wall.
Yes.
That's not what you're talking about.
No, and that's because I don't need to go that far, my lord, because my learned friend, in addition to saying it has to be not on an electronic display and it has to be unchanging, has also now introduced a new element to his definition of, or to his construction, which is that it has to be stuck on the wall. And that, in my submission, is new as of today, actually.
Okay, well,
that doesn't really matter.
But I just didn't want to be under a misapprehension, because I must say, I'll be honest, I had thought, and it's my mistake, that the obviousness case was about the idea of printing off a barcode and sticking it on the wall. And it's not that, is it? It's the obviousness case that you're running, which you say you won on.
Yes.
I know you won on it, but the very specific, concrete, what exactly is it that was obvious?
Yes.
Wasn't anything to do with sticking barcodes on the wall. It was, one might say simply,
yes,
the observation that if you thought about it, you could run a system in which the barcode that was printed was the same
yes,
two goes running.
Yes.
And you would say that would satisfy the claim. That's what the judge was accepting. And you say it wasn't. Schmidt never completed the thought, which is why it's not clearly and unambiguously derived from Schmidt.
Yes.
That was the finding again. You were arguing it was, but the judge decided.
I said there was anticipation.
Yes, you said it was anticipatory, but the judge said it's not absolutely clear that it was saying that you should do that.
No.
But it certainly wasn't saying you shouldn't do it.
Yes.
And then doing it was an obvious thing to do.
Which is why I submit that it was a very small step, which is because I nearly got there on anticipation, my lord, in my submission. Well, you know. But that is relevant when it comes to obviousness. But yes, I said that in a simple public transport system, and this is not, you know, something some outlandish suggestion. Mm-hmm. You have one type of ticket for Zone 1. You know, you have a flat fare for Zone 1. Which is the same every time you want to travel in Zone 1. And
even if it had the date in it, it would still be the same on the same day.
Yes, yes. But it doesn't necessarily have to have the date on it.
I understand. I get that. But even if it did, it would be.
Yes, exactly.
It could be.
Exactly.
But that's what you're talking about.
Yes, that is the point I'm talking about.
And that's what you want.
Yes, because, you know, once we get to sticking on the wall, I can't even remember these points now, but there are actually all sorts of points on infringement about where these things were stuck and, you know, so we say it's hopeless on construction anyway to say it has to be stuck on the wall. I mean, my learned friend would have to come up with something much better than that. I don't know, maybe you'd have to say a sign has to be vertical, not horizontal. I don't know, but it's none of these things are good arguments on construction at all, and the judge was very clear as to what she found on construction. Yeah. And I'm afraid, my lords, that is where I turn to my respondent's notice, unless my lords have any questions on.
No, I think you must do that now.
Yes, I must do it, and I will try to do it very quickly.
We do have to rise in just about half an hour or slightly.
Yes, I'm going to try and do it in 10 minutes. I'll set myself that target. So we don't need to go to the law on construction, other than to just mention one point. So the law on construction is set out in paragraphs 114 to 116, and I do remind my lords at paragraph 116 that the claims are not presumed to be limited to some particular embodiment that is in the specification. So it's quite common to describe various embodiments and preferred embodiments in the description, but the case law is very clear that you can't presume that the claims are limited to that preferred embodiment. And we say that that's one of the reasons that actually the judge fell into error on her construction, because she gave too much weight to the building security embodiment. So that's the law. So when we look at the construction, that is that the judge adopted, she sets out her reasoning, well, the key parts of her reasoning, at paragraphs 152 to 154. And so she says at 152 she's drawing together the threads of these competing arguments, and that the real difficulty is that different parts of the patent's teaching appear to be in direct conflict. And I want to start by looking at the claim language, because we say that what the judge failed to do was give sufficient weight to the language of the claim, and the particular part of her judgment where she fails to do that is at paragraph 154. And she says in paragraph 154, to resolve construction in favour of either party effectively requires the skilled reader to ignore the teaching that the other party relies on. And she considers that the claimant's construction is consistent with the Virgin principles. And in particular, since the patentee has deliberately limited the claim to display on a sign, this limitation cannot be disregarded, even though it conflicts with some of the teaching of the patent. And I think it's probably a good idea. I certainly want to have the patent claims open in front of me, and I'm taking them from Supplemental Bundle tab 4, page 156. And what we have at page 156, lines 5, 6 and 7, is how the claim ended up. Obtaining a graphical encoded information item which is displayed on a display of a computing apparatus, wherein the computing apparatus comprises the display and an electronic apparatus, and wherein the display is a sign. And so we say, just reading that in its natural and normal meaning, the display has to be the display of a computing apparatus, and in the next part of that integer it says wherein the computing apparatus comprises the display. So that is emphasising again that it's a display of a computing apparatus. And then it goes on to say, and wherein the display is a sign. And we say it's important to note that sign has a very general meaning. Just at the moment, looking at the language of the claim and not anything else, sign has a general meaning, which can obviously cover placards and so on, but it can also cover electronic signs. And we say that because of the wording that it's displayed on the display of a computing apparatus, and the computing apparatus comprises the display, that when you read that integer as a whole on its natural and normal meaning, there is a deliberate limitation in the claims here, which is not the limitation that the judge pointed to, i.e. wherein the display is a sign, because sign is general. The deliberate limitation in the claims is that the display is on the display of a computing apparatus. And we say the problem with the judge's judgment at paragraph 154 is that she didn't take into account the deliberate limitation that we say is the only deliberate limitation that you can read in on the wording of the claims, which is that the claim has to be, which is that the display has to be the display of a computing apparatus. Because the deliberate limitation that she is referring to in paragraph 174 is display on a sign. But the only reason she is saying that that's a deliberate limitation is because she's reading in her narrow meaning of sign. And that is not legitimate if we are considering the approach to construction, and in particular the subparagraphs of the Virgin principles that she refers to, which say it's the terms of the claims which delineate the patentee's territory. And it follows that if the patentee has included what is obviously a deliberate limitation in his claims, it must have a meaning. And so we say that her first error is to ignore the claim language, and that her finding that her construction was consistent with the Virgin principles is not correct. The second way in which we say the judge was in error was to ignore the context of the patent. And I've already looked at that context in looking at added matter. Although the specification is slightly different, and we do have to be a bit careful. We can't just adopt everything I looked at for added matter and the A specification, because the oddity about the C specification is that various things are said to be outside the scope of the claims. And so what I pray in aid, and I won't go through this now because time is short, is that lines 30 to 32 on page 136 make clear that it's standard computing apparatus with a display. That's the description, I think, of figure 1. And lines 9 to 11 on page 137, that's bundled page 137, make clear that the controller controls the display and the controller is controlled by the computer readable code. And then I also pray and aid the passage that we've looked at previously in relation to added matter, which appears on page 153 at line 9, which is the description of the preferred embodiment. So that's where you have to have a computer-controlled display in order that the barcode is only provided when there's direct communication. So, I mean, another oddity and mistake in the judge's decision in my submission is that she has worked on the basis that the patentee hasn't claimed the preferred embodiment. She's worked on the basis that they only claimed this one aspect of the building security embodiment. So we say that the mistake in paragraph 153 that the judge makes is saying that the only passage that sheds any light on what sign means and provides important context is the building security embodiment, whereas in fact we say that there is important context in other parts of the specification. Now, the next point I have, and just looking ahead, I've got 6 points and I'm on point 3. So point 3 is that we say the judge has wrongly allowed one sentence in the building security embodiment to be decisive of the meaning of the claim. So everything turns, according to the judge, at paragraph 153, on the meaning of sign in the building security embodiment. And it is fair to say that in the C spec, the building security embodiment is different in an important respect, in that the second sentence is said to be outside the scope of the claims. And I'm going to come to that in just a minute. But we say that her decision that it was all going to turn on the building security embodiment is inconsistent with the case law that we just looked at, saying that you effectively can't construe a claim just by looking at a particular embodiment in the description. And we say, therefore, she's fallen into error in that respect. Now, in relation to the building security embodiment itself, I think I must turn this up because it is different. And so if we just do that by taking up the patent supplemental bundle tab 4, page 149. And it's the well-known passage now, starting on line 13, but it is subtly different. So it says, in such an embodiment, the computing apparatus 10 may comprise an electronic door lock. The encoded information 112312, such as a geo as described above, may be displayed on a sign geographically proximate to the electronic door lock. And then it goes on to say, in embodiments outside the scope of the claims, the geo 112312 may be provided on an electronic display geographically proximate to the electronic door lock. In such embodiments, the encoded information item may be periodically updated, etc. So the important change is that the second sentence says embodiments outside the scope of the claim now.
And that's now made that a plural, whereas the point you were making before is that
No,
alternative wasn't a plural.
Yes, exactly,
In
exactly.
the A specification.
Yes,
Which
indeed,
might
indeed.
to affect the meaning of the next sentence, which now talks about a plural.
Yes, agreed. And so that is one of the reasons why, obviously, the judge decided that whilst she, in the A and B specification, she said this didn't reveal the non-electronic static sign. When it comes to the C specification, she says, now I can read this differently because, as my lord says, there's the words in such embodiments, and that refers back to the previous sentence. But I say that you've still got to bear in mind that the computing apparatus referred to is a cross-reference to the computing apparatus of figure 1, which has a display. So that's computing apparatus 10. That the reference numerals 112, 312, which are referred to in both sentences, but particularly in the first one, which is within the scope of what she says the claim means, refers back to figures 2 and 3, where the geo is clearly shown on the display of a computing apparatus. And I say again, the sign would normally include something that's not static. Again, that different types of signs were part of the CGK, and that in such embodiments is still ambiguous because, yes, it could refer to the embodiments outside the scope of the claim, but equally it could refer to all the embodiments referred to earlier in that paragraph. So it's not, in my submission, decisive. And what the judge has done is, as I've already mentioned, allowed the entire construction of the claim to rest on what is at best still an ambiguous passage, and again an ambiguous passage in one particular embodiment. And this is my fifth point. I say that the judge actually gave undue weight to the parts of the building security embodiment which were said to be outside the scope of the claims, because what the skilled person has to do on the judge's approach to this is not only have they got to zoom in on the building security embodiment, ignoring everything else, they've then got to zoom in on the line that says in embodiments outside the scope of the claim, and decide that they're going to use that, even though they've been told that's embodiments outside the scope of the claim, to construe the previous line to say, I'm going to use what's outside to tell me what's inside. And in my submission, it's simply unreasonable and not consistent with the correct approach to patent construction to have to find the key piece of logic in something which is explicitly said not to be claimed. And we say that that is contrary to the case law, which tells you that you can't use meticulous verbal analysis and you shouldn't use meticulous verbal analysis in patent construction because the skilled reader is being forced to do a task here in order to understand what's in the scope of the claim, which is all the weight effectively is on that one single sentence that's said to be outside the scope of the claims. And so we say that even leaving aside the point that it's a single embodiment and the judge shouldn't have been construing the claim on the basis of that single embodiment, it's also a single embodiment which is ambiguous, and you've got to look at something.
You've got that point. Now, I think we really are going to have to give Mr. Lane a chance to both reply, answer...
Mr. Pritchard.
I'm sorry, Mr. Pritchard, a chance to reply on generally and to answer your respondent's notice.
In that case, I will say that my sixth point, which is the technical meaning of display, my lords, if and my lady, if you don't mind, can be taken from my written argument. So I've set out there, I think, clearly why we say display did have a technical meaning.
I think you've set out your arguments very thoroughly, both in writing
I'm grateful, and I'm sorry I've trespassed too far.
Sorry, Mr. Pritchard.
I'm very grateful, my lord, and I'll have to spend a little time on respondent's notice because you may have seen, because of the way instructions worked, I didn't settle the skeleton on the respondent's notice, and so I need to make sure I need to go first. Nutshell reasons why my learned friend's submission's wrong. We say looked at properly. What my learned friend seeks to do is to construe the patent by ignoring the teaching in the patent that's not helpful to her. She wants to ignore the building security embodiment as a whole, and then separately, as my lord's lady just heard, she wants to ignore specific passages which is not helpful. I'll deal with that. The second point is the disclaimer point, which I'm not sure the extent to which she pressed, which is that in her skeleton at least, it suggests that one should have ignored, the judge should have ignored the parts of the specification which are disclaimed, and particularly ignore the embodiments to the electronic display, which are not claimed, and I say that's wrong in law. If I may, I'll deal with those in reverse order. So deal with the embodiments that are expressly disclaimed. You'll see that the C specification expressly disclaims the electronic screen variants, that's things like the ATM and Figure 2. So it says that outside the scope of the invention. It clearly sheds a light on what the inventor was not claiming, and that clearly sheds a light on knowing what he was claiming. The law in my submission is very clear. It's set out in Virgin, it's equally set out in Wood and Capita. The disclaimed parts are not struck out of the specification, they are still there to be read. Clearly a matter of weight that's given is a matter for the judge, but to suggest they should be given no weight at all is clearly wrong. And they are clearly helpful in my submission because they shed a light on what is not being claimed, which is just as useful as shedding a light on what is being claimed. In those circumstances, I submit what the judge said in the judgment at paragraph 119, 120, which I was going to go to but won't given the time is entirely correct. Those passages also lay down a gauntlet for my learned friend because the judge rightly says in my submission there's no authority for the proposition that the disclaims part should be ignored. My learned friend has not picked up that particular gauntlet and really seeks to re-argue what was said below. I say it's wrong for the same reasons. And the Kieran Amgen point that wasn't pushed out but raised below is wrong for the reasons of my submission that the learned judge said.
I know you haven't got much time, Mr. Pritchard. Can I just make sure I've got one thing clear? Is it right that the patent, the C specification, never explains what it is about the things which are outside the claim, which takes them outside the claim?
That is correct. Yeah. Thank you. But they are nonetheless, in my submission, Figure 2, for example, is very clear that it's...
So you say you can figure it out?
Yeah. And, in fact, that was going to be my next submission, my lord, so I will go over the top of that. The question of verbal meticulous analysis is one for the court, and that's one in mind. Meaning of display, this effectively is a rehash of display means electronic display and only electronic display. So to a large extent, I don't want to go over it again. I would point to what the learned judge said in paragraph 130, 131 of her judgment, which I would invite the court to read. I say are manifestly correct findings. Effectively, my learned friend seeks to rely on evidence for Dr. Barrisso, which the judge rejected, which suggested that the display had to be a display of a computer. And she's clear that the judge has not found that the display has to be a display of a computer, and that is because of the computer apparatus point, which would be over at some length. There is also evidence from this, which I say the judge accepted from Professor Martin. I will, if I may, just give the references to those. Day 2, page 169, line 21. To day 2, page 170, line 25. And there, this is I say the judge accepted. Professor Martin's very clear that in the context of the computer apparatus, display doesn't have to be a computer monitor. Building security embodiment, that I think now really is a little more I can say on that, save to say that the assertion that is given too much weight is simply wrong when one reads it properly with the disjunct and with the fact that I say the wording is very clear, but that's a matter that I have been over at length and don't intend to go over again. Natural meaning of the claim I can take, I hope, quickly, which is the last substantive point on the respondent's notice raised by my learned friend. The important point is that I say it's clear from the judgment, and in any event manifestly device, correct, that a computer apparatus is not a computer, and the display of the computer apparatus therefore has to be understood in context. The building security embodiment is a relevant context. Building security involvement tells you about a sign, and it tells you about a sign proximate, i.e. not next to or on the, sorry, rephrase that, that's incorrect, proximate to the computer apparatus. So it's not any display, it's a sign. So it becomes effectively reflexive on the teaching on page 22 of the building security embodiment. But I've been through that, and I'm not going to go through it again, given I think I have about 5 minutes left. Those very briefly are my points on the respondent's notice. I've taken an extremely fast, so if there's anything I can assist the court in respondent's notice.
One question.
Well, yes.
I understand why you say an electronic apparatus is not a computer, but why is a computing apparatus not a computer?
Because the judge accepted that the computing apparatus consisted of an electronic apparatus plus a display. There was no added matter, and therefore the computing apparatus has to be taken in that context. It's a computing apparatus, not a computer apparatus.
Okay.
That's the point. Now it takes me very briefly to respond to some points that are raised by my learned friend, and I want to perhaps start with the point that I made a muddle of this morning, and which the point I think the court has raised a number of times in relation to what we say a sign is. And static, yes. Non-changing between transaction, which is what the learned judge found between on the C-spec between J153 and J154. Yes. I just want to clear up the confusion about stuck up. I'm not suggesting that the claim requires something that is screwed to the wall or pasted to the wall. That would clearly be wrong. But I am saying it has to be the display of the computing apparatus, and it has to fall within the normal meaning of a sign. And that necessarily means, in my submission, that the printout of the barcode from a terminal is not a sign. It's not a sign for two reasons. One, because it doesn't fall within the normal meaning, and two, because effectively then it's not part of a continuous non-changing system. It's a system that may not change between transactions, but certainly not a system that will not change between transactions. Now I've put that very briefly. Can I help my lords and lady any more on that particular submission? And the reasoning for that construction, I say, falls exactly out of the judge's reasoning on the C-spec in 153 to 154, applies equally, in my respectful submission, in relation to the A specification. There are differences, but on the points that matter, and particularly on the reflexive point on the in such embodiments, which I say clearly applies to the electronic display, applies equally there in relation to sign. But I've been over that ground ad nauseum, and I don't think to go. There are a number of points on detailed points on added matter that I will take extremely quickly, really just to flag up some matters I would respectfully ask the court to take into consideration further references. The figure 1 controller point, which is figure 1 of the A specification, the point here I've already made but would emphasise that this is a reference to equipment and not to the method. It's an exemplification, not conclusory on exactly what is covered. Figure 2, which my learned friend spent some considerable time on, is clearly a web page embodiment. A web page embodiment, by its very nature, is on a computer screen. And if one accepts that the A specification is not directed to just computers, then this is a one but not all embodiments and exemplification. The same is true of the figure 3 embodiment, that differs from figure 2 only in the number of servers. In that context, the disjunct which my learned friend seeks to play down has far more impact, because at that point one is removed from computer apparatus being a computer, and one is into the territory of computer apparatus being some electronic apparatus plus a display. And on that, I would just, on what that display is, ask the court to read and take into account paragraphs 129 and 130 of the judgment, the findings that the learned judge made there in relation to the evidence of the fact that the display is clearly not a display of a computer. The smart tag I won't spend any time on beyond saying that the judge concluded there was no evidence as to what exactly was displayed on it, and to that extent I disagree with my learned friend that it was clearly an electronic sign, but I'm not going to spend any time with that and spend any time opening. The extension of protection, I have nothing to add on that I have not commented on already. In terms of added matter 2, the arguments I would have advanced in reply are effectively the matters that were put by the bench to my learned friend, Miss Lane, and I don't seek to repeat them, I merely seek to urge them on the court. On obviousness, which I come to last, there are a number of, in my submission, important points that need to be made. The first one is to reiterate I'm criticised by my learned friend for, or the submission is criticised for saying that the teaching is split into 2, but if one looks at the teaching from 4 to 15, it's not clear whether a terminal is required. It's clear that the latter part of the teaching requires a terminal because it says alternatively a terminal, but that is not clear in the first part. So if the first part is providing the key impetus for obviousness, I submit that is a significant difference. It's also a significant difference where the final part of the teaching, at the very end of the section, says that you can have an MMS with the ticket on it. So there is at least another method of getting a ticket out of this system disclosed, which does not involve having a terminal. So that is why we focus on the split into 2. My learned friend made a lot of detailed points about why the Schmidt reference, in fact, is not a primarily dynamic reference. I don't have time to go back over that, but I would respectfully ask the court to look at supplementary bundle page 12 and the description there in Schmidt, which in my submission illustrates why its primary thrust is as a dynamic teaching. I'm not saying it is, I'm not disagreeing with the judge to the extent that she says there is nothing else there, but it is clear that that is what is concerned with, not with something else. On the evidence, my learned friend jumped over a key passage. I don't intend to do any more island hopping, but there is a key passage on page 383. She started at the top of 389, I'm so sorry. Day 3, 389, she started at the top, she jumped to the bottom. There's a bit in the middle. More importantly, I'm conscious that it is a burden on the court. I do say that one has to read the whole of our cross-examination together with the equivalent piece of cross-examination.
Well, for my part, I did read it all.
I'm very, very grateful. I'm not surprised, but I have just some reticence in urging the Court of Appeal to read evidence references. Well, in that case, my lady, my lords, have my point on that. Our respectful submission is that the judge didn't have a basis from that cross-examination to reach the conclusion she did, and particularly if I am right on the submission as to what a sign is, then there is certainly not the material necessary to do so. I think that is 1:15, and I have no push from behind, so unless I can assist my lady.
Mr. Bridger, I do have a question for you, because I'm slightly puzzled about something. You started with your submission about what sign means. And at least if I understood what you were saying, what it sounded like you were saying is that the concrete example I put to your opponent about what the judge had held was obvious, you say isn't within the claim.
Yes.
But if I've misunderstood you about that, this is your chance to tell me, and just to repeat it, just for the benefit of me at least.
Yes, perhaps I can tell.
What I understood the judge to have concluded was that it was obvious to have a system in which the ticket machine prints out on sequential occasions, let's say, the same barcode twice.
Yes.
And that's within the claim. And that's why your claim is obvious, and well, that's why your claim is obvious.
Yes.
Now, I think, but it's not clear, you would say that isn't within the claim.
That.
But if that's your case, I don't find it in your grounds of appeal.
That I will have to check.
Well, first of all, is that what the essence of the submission you're making to us?
That is the essence of the submission I am making. Yes.
And why? And just to explain it for my benefit, why isn't it within the claim? So this is the machine prints out the same barcode twice for the first customer, and then because it's the same, they're an adult and it's the same line and it's the same day, it prints out the same barcode for the next customer. That's not within the claim because
It's not a sign.
because
Because a sign has to be effectively something that is
Not displayed, you say. It's not displayed, presumably you say.
It's not displayed. It's not.
no, that's not what I thought you were saying before. I thought the reason why
Sorry.
you say it's not within. So forgive me, Mr. my Lord. I thought what you were saying, Mr. Pritchard, was it's not a sign because it's not unchanging in some way or something. It can be changed. It just hadn't been. It could have been changed, but didn't, and that's not within the claim, as I understand your case. I think, and I'm not trying to.
My submission. Can I roll back, my lord? There has to be a display for the computer apparatus, and that display has to display the encoded information item.
Right.
That display is said to be a sign.
Right.
My submission is that a sign is not, in that context, something that is printed out on a transaction by transaction basis by the terminal.
Okay.
Because that is no longer the display of the computing apparatus, which is a sign.
Well, that's a different point from the point I thought I was asking about, but fine, let's get it out. That's good, and that's the one my lord put to you. So you say it's not a sign at all if it's just printed out, because it's being printed out. Nothing to do with changing.
Well,
No.
I thought what you said was this, you're not suggesting it requires to be up against a wall, but you do say it has to be the display
it has
of the
to be
computing.
displayed. So up against a wall comes as a function of the proximate part of the door lock embodiment, because effectively it has to be up against it, or it could be stuck to the door lock, it could be stuck to the door, but effectively that's
One way or another, it has to be the display.
it has to be the
So
display.
you say if you print out a ticket, in those senses, that's part of the display.
Yes.
I'm not talking about the printing out of the ticket, Mr. Pritchard. I'm talking about the printing out of the barcode.
Sorry, I meant I answer. It's my fault for not critical. I understand that.
I see.
That's what I was answering.
Yes. And you say because it's being printed out, it's not a display of the electronic apparatus. Right.
Because it's
So it's nothing.
it's got to be two things, my lord. It's got to be. Sorry. Be very clear. It's got to be a subset of a display, and that subset is a sign. So
Right.
they are two nested. My lord
Right,
is.
no, I get that. Now you'll show me where in the grounds of appeal you've taken this. Because I must say, I don't think in the grounds of appeal you have taken the point that says that the thing the judge found was obvious is not within the claim, and therefore the judge's finding on obviousness is irrelevant to the validity of the patent, which is what you've just submitted to me.
I think that may be a function, my lord, of where we've arrived at today, but nonetheless, it goes to the grounds of appeal.
I mean, if I missed it, Mr. Pritchard,
No,
I'm
I'm
first to apologise. But I
No, my lord.
If I understand your grounds of appeal, you say the judge shouldn't have reached the conclusion she reached about what was obvious.
That is correct. That is correct.
Yes. This is a different point. This is a point that says that the thing that she found was obvious doesn't invalidate your patent.
Correct. And to that extent, I think the reason I've arrived there, and that is my fault, is where we've arrived in the discussion over the meaning of sign today.
Okay.
I'm not sure I can assist further on that at the moment, at least without taking instructions in relation to the grounds of appeal.
Anything else?
Not from me.
Well, I think technically Slade has a right of reply on the respondent's notice, but I suspect there's not much to add, is there?
My lords, there is not much to add. No, I'm not. In fact, I'm not going to add anything.
Thank you very much.
That clear.
Well, we will reserve our judgments. You will receive the drafts in the usual way to the nominated parties, and you're all very familiar now with the strict restrictions on what can be done. And if you can let us have typographical corrections only, and try and agree an order. And if you can't agree, anything you can't agree, let us have written submissions and we'll decide those on the papers. And then the hand down itself will be electronic with no attendance, usual way. And as I say, thank you very much to council and to everyone behind them. I know that a lot of work goes on at all parts of the teams. Thank you very much.
Authorises,